Hey folks, this is Rob Wells here with you from the law office of Robert M. Wells. Our office helps out landlords and property managers deal with their landlord-tenant situations and problems. In this video, we're going to talk about whether or not a tenant's refusal to allow the owner or the owner's agent entry into their unit pursuant to a written 24-hour notice to enter is just cause for terminating a tenancy under the Tenants Protection Act. Now, before I begin, landlords, property managers, if you're dealing with a situation where you're having a tenant refuse entry into a rental unit, or you're having difficulty making entry into a rental unit, please feel free to reach out to us below. Now, let's begin. Now, the question again is, can I terminate a tenant's tenancy for just cause under the Tenants Protection Act for their refusal to allow the owner or the owner's agent in pursuant to a written 24-hour notice to enter or notice to entry? The answer is yes. The Tenants Protection Act of 2019 actually states on its text the tenant's refusal to allow the owner to enter residential property pursuant to Section 19, Civil Code 1954, and there's a couple of health and safety code sections too, which are related to a landlord's ability to look for, and check for smoke detectors and carbon monoxide detectors. I think there's one on point for inspecting decks and so forth in the health and safety code as well too. So the answer is yes. The tenant's refusal to allow the owner entry into the unit can be just cause for terminating the tenancy. Even though the Tenants Protection Act uses owner, the parlance of owner's agent, specifically pursuant to Section 1954 of the Civil Code, there are a number of different grounds where a landlord can specifically enter a tenant's unit, particularly to effectuate repairs, improvements to the property, exhibiting the unit for, to contractors and so forth. Also, to show potential and buyers or actual buyers of the property, or mortgagees, or basically your lender. Basically, if you needed to do an appraisal, for example, to get a loan, you could also enter pursuant to Section 1954 of the Civil Code. There are a lot more things, but those are like the main items here. So my thought is it doesn't have to be specifically the owner. It could be the owner's agent, like their realtor, their contractor, that type of deal. Now, this is kind of throw this out there. This is kind of a point for landlords. You always need to have a written rental agreement, and you need to have terms in the rental agreement that allow you entry into the home for these various purposes under the California Civil Code. Because if your tenant refuses to allow you entry into the property, and you have a written term in your rental agreement, that becomes a 3-day notice to perform. And if you're subject to the Tenants Protection Act, you would have to give 2 3-day notices: a warning notice telling your tenant, hey, I need you to allow me entry. This is for a specific purpose. The other, and if you don't comply, we're going to give you a 3-day notice to quit. If you don't have these terms in your rental agreement, such as you got an oil agreement, you may be forced to actually use a written, just a 30 or 60 day notice for cause, basically, at that point, if you don't have provisions in your lease that allow an owner or your agent's entry into the home as a lease term. Because I can get it on a 3-day notice to perform if there's a lease term, because that's a breach of a material term. But if you don't have that term, although the Tenants Protection Act provides that as cause, you may be forced to use a 30 or 60 day notice to terminate the tenancy completely. These are always going to be highly factual situations, which you might want to talk with an attorney about. If this is something you're thinking about doing or you need help with, we're here to help you out. You can reach out to us below here, and we can talk about your case situation based on what's going on. Because the law, although it gives you the ability to do this, whether or not it's gonna, we have a situation where, you can prove that in court, or you're gonna have issues with going about terminating the tenancy. You want to know that stuff ahead of time versus, hey, doing it in court and then finding out you have a problem, because these things do cost a little bit of time and money, and you just don't want to be wasting a bunch of time or money dealing with this stuff. So, folks, until next time, we'll talk to you then, and we'll see you then. Thanks.